Hi, everyone. Your success is worth protecting. So, I'm going to tell you in the next 30 minutes why you need to express your wishes in a written plan. Goals of the workshop will be that if you have any questions during my presentation, just go to chat and type in your questions and then click send. I'll answer your questions at the end of this program. A little about me. You can see this is a representation of my family. My wife is sitting next to me. My children, my children's spouses, and my grandchildren. Why do I do this? I've been practicing law for many, many years, and I've had a lot of trial experience. I was a judge. I had been an assistant county prosecutor up in Essex County. And as the years went by, what I want to do is really spend more time in helping people out. And I found there was a tremendous need in people preparing estate planning. So it's really all about family, making sure that you're protected and your loved ones are protected. So let's keep it simple. We can do this with 3 or 4 documents. First of all, a last will and testament, a healthcare directive, financial power of attorney, and if needed, a trust depending on your particular situation. So the government does rule us while we're alive and also after death. If you have no will, then the state will have their own rules and they control. Who gets my property? Those are beneficiaries. At death requires probate government process. Administrator will be appointed by the court and a bond may be required. With a will, however, a person who went on the internet and downloaded a will form, they prepared something. As a matter of fact, I had experience with this, working and helping out another law firm. This particular individual went on the website, on the internet, and prepared a will, filled out all the blanks, went to a notary, had it signed. When she died, her beneficiaries attempted to probate the will, and the surrogate's office said it was invalid, did not comply with New Jersey law. That individual then spent $5,000 to retain an attorney. The bill now is up to $10,000. And talking to that law firm, they anticipate that they're going to have a difficult time being able to have that will, or purported will, accepted by the surrogate's court. And it may go up to $15,000. In the meantime, expenses are being incurred by the estate, and the individuals involved have no authority to be able to act. They need court approval. What a mess. Only a few $100s would have corrected all this, and there would have been no problems. So, in a will, you choose your executor, and also there's no bond required if you have a will. So how many of you at this point in time have a will? Are you sure it will work? Serious defects in a will. I'm going to tell you a story about a wealthy woman who lived in New York. She was a multi-millionaire, and she had a will, and she also, while she was alive, lived with a woman that was her lover, and she wanted to provide for her. So at some point in time, she went to a friend, not a lawyer, who said that he was familiar with the internet and he could go on site and help her make an amendment to the will. Well, it turned out that the original will that had been prepared many years ago said that if the individual that she was living with did not survive her by 30 days, then the testator was to be assumed to be surviving her girlfriend. Well, it turned out when the woman who was the testator died, the female lover died 12 days later. That female lover had a daughter, and the daughter of that individual went to court and lost because it was in the will that she had to survive by 30 days or more. Since she did not do it, everything reverted back to the testator's estate, and other individuals and parties were able to receive the money. Thousands and thousands of dollars were spent on this. It should easily have been corrected if she had just gone to an attorney. Another story is about a woman in Florida. Situation somewhat similar. However, in this situation, the woman had a daughter, and they were estranged. The daughter had not spoken to the mother for more than 20 years. However, during that period of time, this woman developed a good friendship with the next-door neighbor who took care of her. And as she got sick, the next-door neighbor would be at the house every day, making sure that her needs were taken care of. And the woman wanted to prepare a will that would provide for this woman that's next door, and not her daughter, because she wasn't getting along with her daughter. So she went on an internet, prepared a will, signed it, and when the daughter found out about that will, that she was being disinherited, she filed a lawsuit. Well, the court said the will was not properly prepared, and therefore the woman that was next door, who took care of this woman for many, many years, got zero. And the daughter, who did not get along with her mother for the past 20 years, got everything in the estate. So completely contrary to what was desired and wished for. Government rules. As I've just mentioned, you have to comply with the rules of the state as to how these documents are prepared. Now, in New Jersey, probate is not much of a problem. In New York, it's a little more involved. In both states, the process is made public. Taxes have to be paid, and estate taxes in New Jersey don't exist. However, there are federal taxes. If you have more than approximately $5.5 million, there'll be taxes on that. Inheritance tax also has to be paid both in New York and New Jersey, and it can go up to 16%. Government rules again. During your lifetime, if you have a power of attorney, you can prepare a document to give someone legal authority to handle your financial matters. You can also develop a power of attorney for a healthcare directive. That's, in other words, for a living will, end of life. And that individual or a group of people will make decisions after getting advice from a doctor as to what you want done in your care when you can't make those decisions because you're either too ill, you're comatose, or whatever. Now, what if you don't have these? Well, then individuals who believe that they're going to inherit, or heirs at law, will have to seek a guardianship requested in court. 2 doctors are required to say that you're not competent if you don't have that power of attorney. And there'll be a hearing, a trial, and there's attorney fees. And if there's a health care directive in existence, that's fine. But if you don't, then your members of your family may very well have to go to court to get the authority to be able to decide medical matters on your behalf. Distinctions between documents and planning. Power of attorney, healthcare directive, last will, and testament. If made part of a plan, they will complement each other. But if not, you run the risk that they may be in conflict and cause problems and financial expenses for your family. Excuse me. So there was an individual that came to our law office where she had a power of attorney. She also had a living will. The problem is they conflicted with each other. The power of attorney gave a child not only financial authority, but also was a medical directive, and the child was able to make medical decisions in case their mother was too ill to do it. However, her living will was executed when she was in a hospital, and that contradicted the power of attorney. That said that the doctors had the final word. She was not aware of the contradiction until I brought it to her attention, and telling her that if it was left that way, Her child, who had the power of attorney in the original document, would have had to go to a lawyer, spend thousands of dollars, go to court, and insist that she had the authority rather than some strange doctor that might have been treating her while she was visiting someone in another state. 3 steps to plan and protect your estate. Know the rules. If you do nothing, the state and the federal governments will, including the IRS, will dictate what happens to your assets and your estate when you're alive and also after you die. Creditors, family, and Medicaid future creditors will be an issue. Know your options. You can create a personal plan that explains your wishes and it'll be honored. Everyone has their own concerns, issues you should consider in creating your own plan. If you're single, married, second marriage, are you widowed, your family situation, do you have children? Are the children living at home? Are they in college? Are they married with their own families? Do you have grandchildren? Relatives with disabilities or special needs? Yes, absolutely. It's all about family. Know your creditors, known or potential. Long-term care costs nursing home about $12,000 per month in the state of New Jersey. Your family, your child's spouse, or one of your children who has financial problems becomes an issue. Lawsuits not covered by insurance. These are all potential creditors. Unanticipated and unintentional predators. There again, your family, spouse, blended family, remarriage, long-term care, as I mentioned earlier, your children, your beneficiaries, bankruptcy, addiction, disabled or becomes disabled. We say people are healthy, but God forbid something can happen. People get into an accident or illness and they become disabled. Divorce, it happens. Financial aid, grandchildren in college, you want to help them out, and there's a proper way of doing it, and there's also ways that you think you're helping the college student, and actually it hurts them. Lawsuits, yours and your beneficiaries. Long-term care costs, as I said earlier, it's approximately $12,000 or more a month. So you have to ask the question, how you pay for this care? Medicaid, they can place a lien on your home. They're not going to remove you or your spouse, but they may more than likely put a lien on it. So upon your death and your spouse's death, they may very well want to sell that house so they can be reimbursed. You do not have to give your assets away to protect them. Medicaid, however, will look back 60 minutes to review your financial records, and if they decide that you transferred your property for less than market value, they will consider it something to attach. But you don't have to wait 5 years to do your planning. Actually, the sooner you act, the better. So you have to know your options. What is estate planning? There's 3 core elements. Who is in control? Obviously, you want to stay in control. Who gets the benefit? This is your choice. When? Alive and well? While you're incapacitated? Deceased? Your spouse incapacitated? Remarried? And then upon her death or his death? Child? And if they're in a valid marriage and safe marriage, fine. If they're divorced, what issues are you going to be dealing with? How do you want to handle that? Use the government's rules to achieve your own integrated estate plan. So typical goals of estate plan, what most people want, obviously you want to stay in control. You don't want to become a burden to your loved ones, and keep it simple. My goal for your plan, for you to know the difference between documents and planning. Understand all the costs and how to minimize them. Know your options and choose the plan right for you. Trust basics. What is a trust? Well, basically a trust is a document that permits you to put your assets or whatever you want of your assets. You don't have to put everything in, but you can choose what you want to put in and what you want to keep out. And then you notify who's ever holding it, whether it's a bank or a brokerage, that you're going to be putting your asset into the trust. So how do estate laws treat a trust? How and when should a will and a trust be used together? You definitely, if you have a trust, you want that will to work together with it. And a trust can very well be extremely helpful in protecting your children and any other beneficiaries that you have regarding taxes. And I'll get to that in a moment. So if a crisis occurred now, would you qualify for Medicaid? What if you plan now and you're healthy? Well, meet Mr. and Mrs. Jones, age 74. They have assets about $777,000. If they give away now, how long will it be until they could qualify for Medicaid? Well, obviously, if they get rid of everything, then they probably would. But there again, remember, it's got to be of equal value. If they don't, they just give it away, Medicaid's going to say, you don't qualify for Medicaid. So could they protect their assets sooner? Mr. and Mrs. Jones Protection Plan. Total assets, $777,000, is totally at risk. However, with a plan, immediately they can protect $649,000. Balance at risk is $128,000. And if every month for 37 months they paid approximately $3,459 a month, that at some point in time after 37 months they would be completely protected. So we all have our own numbers, and that's what we have to work out, or you have to work it out. So how do we protect our house and money? We agree our success is worth protecting. So what can we do? There's such a thing as a revocable living trust. That's a RLT. You can put things out, you can put things in, you can take things out. But so can your creditors. You then have an irrevocable trust. You can put things in, you don't have the authority to take it out, but your trustee can. Or you can have a situation where the irrevocable trust will protect certain assets that no one can touch. It's there to protect your beneficiaries, and you can take something out, such as interest on money that you've got in a bank or dividends, etc. How do I create my rule book with my voice that actually works? How to create a plan that works. First of all, create your plan with your rules, your voice, and a will, power of attorney, your health care directive, and or trust. Integrate your rules with your life. Maintain your plan as life and law changes. Without all three, your documents usually become ineffective and don't work. Remember the stories, you have to work together and put all these things documents so they're aware of each other's existence. Distinction between good marketing versus good lawyering. Personal options. Beware the TV info commercials that promise you spectacular legal documents at extremely low prices. You know the old saying, you get what you pay for. Remember the stories I told you earlier? Those people meant well, but were misled by slick and misleading advertisements or unqualified friends. So who suffered? They didn't, because they weren't around, but it's their beneficiaries and their loved ones that suffered because of financial expenses, and also possibly not even getting what you wanted them to get. Joint accounts. What about them? Joint accounts are good, but if a large amount of money is in the account on the death of one person, the survivor may be limited to 50% until the state releases the funds. That can be a burden because you may have extra bills to pay and you need to take more money out and you can't get it. So once I create my plan, am I finally all set? Yes, unless things change, such as your family situation, finances, health, and law. We see this with coronavirus right now going on. Things are changing for people. They did not plan for it. You should review your documents every few years. So You have to ask your question. You have to maintain it. Yes. You need to ask yourself these questions. What will it take to protect you and your property? To answer common questions about, well, what about capital gains? How does a trust save your children from this tax? Well, in reference to capital gains and saving your children, let's give you an example of you bought a house many years ago and you paid $150,000 for the house. Upon your death, the house is worth $500,000 or more. Well, without doing anything, then if your children sold that house, they would have to pay the taxes regarding capital gains on the increased value from the $150,000 to the $500,000. So that would be $350,000 that they'd have to pay taxes on that profit. However, if you put that house in a trust, then upon your death, if it's evaluated at $500,000 and they sell it for $500,000, there's no tax because the trust doesn't die. That's an advantage of the trust. Does your current plan meet your goals? What should you do now to get your missing documents ready? And what's missing? So are you set? It only takes 3 easy steps. Now you have to act. Assess your needs, create what's missing, and tie in your plan with your life wishes. And if interested, contact me in the next 3 days to schedule a free virtual meeting to discuss your personal concerns. At email info@danielelawllc.com. Now, prior to that, when you do set that up, what I would need is for you to make a copy of your current documents and email me a brief statement of your questions. Provide me with a brief wish list, and at our meeting, I'll provide options to create what's missing. I'll let you know the cost of the various options, and it's up to you what you want to do. Thank you very much for your time and listening. If you found this helpful, please share it with your friends and family. And now, if you have those questions that you submitted earlier, I'll now spend some time with you and attempt to answer you. Thank you, and goodbye. And stay safe.